Any mention?
My lord, I beg to mention item number 5, my lord. I have informed the other side.
Which other side?
Mr. Paul, I have informed. I have already informed.
No one is there. Okay, just add the request meet on behalf of the state respondents. This is matter after.
Item 5. Oh, yes, sir.
She's there. 2 weeks, my lord.
After 2 weeks. Yes.
Reply of it.
May it please, Your Lordship, I beg to make a mention of item number 2. Lordship, my senior counsel is having some personal difficulties. I humbly pray this matter may be listed after 2 weeks. I have no objection, Your Lordship.
A prayer, just say a prayer as we need on behalf of Mr. K. Paul, Learned Senior Counsel, preparing for the petitioner to adjourn the matter by 2 weeks. So, Learned Counsel for the respondents have no objection. Prayer alert, list after 2 weeks. Yes.
Lordship, similar prayer for item number 8.
Who is appearing for the state here? Item 8. Yes, Mr. Gurung.
Item 8.
Side. Yes, item 8.
My lord.
No objection.
No.
Just say as requested by the petitioner. List is met after a week. Yes, after 2 weeks. After 2 weeks.
Much obliged.
No, please, Your Lordship. Your Lordship, I beg to mention item 19, Your Lordship. Taking the
number?
consent of the other state. Item 19, Your Lordship.
Yes.
No objection, Your Lordship.
This just is requested by the petition. This is met after 2 weeks.
2 weeks, Lordship. Obliged, Lordship. Highly obliged.
May I please, Your Lordship, I beg to mention item number 7. I have already received consent from the respondent side, madam.
When?
After 2 weeks. 2 weeks.
Yes, this as requested by the Learned Counsel for the respondents. This is matter.
Actually, I have the petition. She is responding.
Okay. That is what the problem is. You see, Mr. Bonto is because this is saying one thing and your position is different. You just say as request by the Learned Counsel for the respondent and not objected to by the Learned Senior Counsel for the petitioner. This is matter after 2 weeks.
Your Lordship, I beg to mention item number 15 and 16. It's a connected matters. So let this matter may come up after 2 weeks, Your Lordship.
I'm appearing for the state in item number 15.
Lordship, I am appearing for private respondent in 15 and 16.
You're making a request on behalf of the petitioner.
Yes, Your Lordship.
And Lordship, in item 16, Madam Yangi is appearing for the state, so she's on leave.
My lord, I am here on her behalf.
You are appearing for the state, isn't it, Dr. Agarwal?
Yes, Lordship. I'm appearing in item number 15.
16, Mr. Kaki.
I am appearing on her behalf, not today.
Okay. Yes, this also. Just say as requested by the petitioner. This is matter after 2 weeks.
Highly obliged.
My lord,
Deeply obliged.
Yes, Lordship. Expect to mention item number 17, Lordship. For the private respondent, Lordship. Can you allow us?
The respondent.
Yes, Lordship. Can you allow
Private
us?
respondent.
Yes, Lordship.
For the petitioner.
Yes.
Can you allow us 2 weeks' time, Lordship?
This is also a application for quashing.
Question.
Yes, Lordship. 2 weeks' time, Lordship. Lordship, if 1st November may kindly be given, Lordship.
Yes, okay. As the request made on behalf of respondent number so and so. Okay. Yes.
Obliged.
Obliged, Lordship.
Lord, I beg to make a mention of item 4 of the hearing list, my lord. I'm praying for 2 weeks' time, my lord.
Yes, that is that.
Yes, my lord. Next date I'll try to finish it.
No objection, Your Lordship.
This also is executed by the learned counsel for the petitioner and not objected to by the learned counsel for the respondent. List is matter after 2 weeks. Yes.
Obliged.
Lord, I'm making a mention on behalf of Mr. Jha, my lord. Due to some personal difficulty, my lord, he cannot appear. So item number 3, my lord, let this matter come up after 2 weeks, my lord.
No objection, Your Lordship.
Just say as requested by Mr. N. Sinkan.
Obliged.
Learned.
Please, Lordship.
This will be just as requested on behalf of Sons after 2 weeks. Yes.
Lordship, I beg to mention item number 1 from the supplementary list.
Item 1.
Yes, Your Lordship.
Yes.
Lordship, the conducting counsel has some personal difficulty.
Supplementary list.
Yes,
Oh,
Your
there is supplementary list. Yes.
Lordship, this matter was referred to mediation, if your Lordship recall, on the
Yes.
23rd of September. So that has failed,
Mediation has failed.
Lordship.
Then
Matter may be listed next week. Is it convenient next week?
Yes.
yes. We'll just say the joint request. At the joint request made by the parties. List is matter after a week.
Obliged.
Your Lordship, similar pref item number 14 from the daily list.
Who is there in 14?
No objection, Your Lordship.
Your Lordship, I prefer 2 weeks' time, Your Lordship.
So this is item 14 as requested by the petitioner. List is matter after 2 weeks.
Highly obliged.
Obliged, Your Lordship.
Please, Your Lordship. Lordship, beg to mention item number 9, Your Lordship.
Yes.
Your Lordship can have this matter after 2 weeks, Your Lordship.
No objection, Your Lordship.
This also the request made on behalf of the petitioner. List is matter after 2 weeks.
Lordship, item number 10 also, Your Lordship.
Yes.
Item 10, Your Lordship.
Item 10. You made a mention of item 9, isn't it?
Yes, Your Lordship.
Now item 10. eh?
Lordship, this is a joint prayer for adjournment today, Lordship. Item
Which one?
10. Item number 10, Lordship.
Item number 10, you are for the petitioner.
I am for the petitioner.
And who is for the respondents?
I'm for the state.
Oh, Lordship. I apologize.
You do not know you are appearing for which party.
Lordship. My apologies. I'm for the respondent MPIC, Lordship, in this matter.
Yes.
No objections, Your Lordship.
As requested by the learned counsel for the respondent number so and so. List is matter after 2 weeks. Yes.
Lordship, I beg to make a mention on behalf of Mr. S. Thapa, Lordship, for item number 13. He's in bereavement, Lordship. I'm praying if this matter may be listed after 2 weeks.
He's on bereavement.
Lordship.
Item number
13, Lordship.
1-3.
1-3. For respondent number 2.
Is appearing for the respondent.
Yeah, Lordship.
Okay. This also as requested by Sonja. This is matter after 2 weeks.
2 weeks, Lordship. Highly obliged, Lordship.
Please, Your Lordship. Lordship, I'd like to mention item number 18, Your Lordship.
Yes.
Your Lordship, in this matter, we need to reconstruct the file, so Your Lordship kindly give us 2 weeks time, Your Lordship.
This also 18 as prayed for by the learned counsel for the petitioner. This is matter after 2 weeks. Yes.
Similar prayer for item number 20, Your Lordship.
Who is the other side? Item 20.
I'm for the same respondent here in
Any
item number
objection?
20.
Your Lordship, as per order 2908/2024, Your Lordship has given us an opportunity to file an additional affidavit. Your Lordship, I kindly pray for 2 weeks time, Your Lordship will file additional affidavit.
That is pending for filing of additional affidavit by you.
My lord, on the 29th of
29th
August, the
of August.
petitioner make a prayer
Yes, Your Lordship.
that they would like to bring some documents and FIR. So Lordship has permitted. So they have not filed.
We'll file.
Anyway,
Lordship.
just they're asking for time. You have any objection?
No, my lord.
This also as requested by the petitioner. This is matter for 2 weeks. Yes.
Much obliged, Your Lordship.
May please, Your Lordship. Your Lordship, I beg to make a mention of item number 12, Your Lordship. I'm praying for 3 weeks' time, Your Lordship.
No objection, Your Lordship.
This also the say as requested by the Learned Counsel of the petitioner. This is matter after. Yes.
Much obliged, Your Lordship.
May I please, Your Lordship? I'm making a mention of item number 11, Your Lordship. Due to personal difficulties, my senior is unable to take up the hearing.
You're appealing for the petitioner.
Yes, Your Lordship. May the matter be taken up after
No
2 weeks.
objection because the conducting counsel for the state, also Mr. A.H. Hazarika, is not available.
What is the matter? You know, you have any idea?
Service matter, Your Lordship. School.
This also as requested by the Learned Counsel for the petitioner. This is matter after 2 weeks. 2 weeks.
Yes, Your Lordship. Highly obliged.
Deal causeless, item number 1.
May it please your lordship. May I begin, madam?
Yes. Yes.
May I begin, madam? May I begin?
Yes. Yes. Please.
Lord, this matter pertains to the erection
The
of.
parties are ready, isn't it? All the parties are ready.
Thank you.
No, whether you all are ready. You all are ready. It should not be something like that we do.
But my senior is still in courtroom number 2. But
If he's coming, then it's okay. All right.
they
It's
can
all right.
proceed, Your Lordship. They can proceed, Your Lordship.
What is the matter about?
Lord, this matter pertains to the erection of a boundary pillar between 3 Akings, Lord, 3 Aking land. Now, these 3 Akings are Sokadam Aking, the Asil Aking, and the Bolgri Aking, Lord. They have a common meeting point. The boundaries of these Aking have a common meeting point at a place that is referred to as the Prab Gitok. The Prab Gitok is located alongside a stream that is known as the Mango Jabia stream.
Yes.
Now, off and on, my lord, since it's been a long time, Lord. In fact, there's been a series of 4 rounds of litigation.
This is a matter relating to boundary dispute.
My lord.
Between 3 Akings.
3 Akings, my lord.
And all 3 Akings are party here.
All three Akings are not the parties here, my lord. All 3 Akings, only the party against whom we are aggrieved by, my lord. We are not aggrieved with any other.
So
only
the third Aking is not material for the purpose of this case.
No, my lord. Because the boundary dispute for the present time is between the Asil and the Sokadamgiri, my lord.
You are
for the Sokadam. And respondent number 4 is for the Asil Aking, my lord. The dispute is between these 2 Akings, my lord.
So, respondent number 4, why is the party by name?
No, he's the Nokma, my lord. He's the representative of the Aking, my lord. He's the Nokma. Okay. I also stand as a Nokma here, my lord. Okay. So, my lord, it has been, as I said, my lord, there's been a series of 4 litigations. It all started in 87, my lord. 86, 87, my lord. 87, 88, my lord. By way of litigation before the Court of First Instance, which is the EM, and thereafter it travelled by way of an appeal. After that, Lord, it travelled by way of a civil rule, number 744 of 89. That was in 1989. Then, my Lord, in the year 1995, on the 6th of December 1995, there was an order passed by the Honourable High Court then, Lord, of the Guwahati High Court, directing for a survey to be conducted by a commissioner, Lord, appointed by the court, whose name was R.D. Chetri. He presented his report on the 4th of May 1999. That will be at annexure 2, Lord. Annexure 1, Lord. Report of R.D. Chetri. There he presents my lord the report, and he relies in that report on a survey that had been conducted way back in 1929 by the then Deputy Commissioner of the Garo Hills.
Where is that report of survey?
Report of the survey is here, my lord, in annexure. It's an annexure 1. It's an annexure 1, page 17, my lord.
Page 17 is a
No, that's the
copy of
direction, my
order
lord.
by the High Court.
The order of the High Court appointing him as the thing. Annexure 2, my lord, I'm sorry. Annexure 2 will be the report of the survey.
What is the order of this High Court by which it was sent for survey?
Survey, my lord. That is on the 4th of May 1990.
Now, what happened? Which way this the writ petition was closed?
It was closed with a by way of the judgment, Lord, which will Lordship will find on annexure 4, page 41, Lord. Page 41. It's page 34. So sorry. Page 34, my lord.
Page 34.
34.
Yes.
The relevant paragraphs will be at page 40, my lord. At point number 8. Page 48, point number 8, my lord.
Yes.
If I may read, my lord.
Yes.
My attention has been drawn to the order passed by this court on 6/12/95 appointing Sri R.B. Chetri Advocate Tura as a commissioner for the purpose of resurvey of the disputed land. The commissioner was directed to take into consideration the following aspects during the course of survey: to demarcate the boundary of Asal Aking in accordance with the map prepared on 19th March 1929 by the then Deputy Commissioner of Garo Hills, with particular reference to location of the Prab Gitok, which is admittedly the meeting place of three Akings, Asil, Sokadam, Rongra, Bogri, and the Mangojebia stream and Asim stream, Lord. In compliance with
all these Akings were party to that list.
Then.
Yes.
Now the dispute is just between the Sokadam and the Asil. We have no dispute against Rongri Bodgrim. In compliance with In compliance with the officer direction, the Commissioner has submitted a report which indicates that the disputed land pertains to the Sokadam Aking. So he arrives at a finding on the basis of the 1929 report. 1929 survey, which was conducted by the Deputy Commissioner of Garo Hills then, that the land in question, where the Gitok should be erected, it belongs to the Sokadamgiri Aking. He arrives at that. Now they say that this report was disputed by the other side. However, the same was never challenged.
Just complete the reading of the order.
In compliance with the officer direction, the Commissioner has submitted a report which indicates that the disputed land pertains to Sokadam Aking. But this report has been disputed by the petitioners who have filed objection under oath as to the propriety and correctness of the report. This court, in exercise of its jurisdiction under Article 226, cannot be expected to enter upon the minute details in order to examine the propriety of the report submitted by the Commissioner. Examination on this behalf would naturally entail the attention of this court into various aspects in any considered opinion. The matter requires an in-depth scrutiny of various factors, and it can be better looked into by the court of first instance, which will also have the opportunity to make local inspection to verify the features at the spot. As discussed above, I am in a station to hold that the fundamental principles of judicial procedure in the trial conducted by the court of the first instance have not been followed in the instance case, and that the matter relating to the propriety and veracity of the survey report cannot be properly appreciated by this court in exercise of its powers under Article 226 of the Constitution. In view of this, I consider that the matter should be remanded back to the court below to take decision in matter fresh after giving opportunity to the parties to adduce evidence. In the result, the impugn judgment passed by the Chief Executive Member on 17/12/88 in GDC Revenue Appeal Case Number 4, Miss of 1987, and the judgment of the Court of the First Instance dated 20th November 1987 passed in GDC Revenue Number 298, Miss of 1986-87, are hereby quashed. For being contrary to the principle of law, the case is remanded back to the Revenue Member for fresh trial in accordance with the principles and guidelines as laid down in Garo Hills Autonomous District Special Customs and Usages Validating Act 1958 as interpreted by this court in Smithy Dore Summers case.
You were a petitioner there?
In this case, no, Mulad. In this case, I was the respondent. Mulad.
Respondent number?
I was respondent number 1, 2, 3, and 4. Mulad. 5.
You are respondent number 5?
No, all the 5 respondents. Mulad. I was representing all the 5 respondents.
You are Nokma, isn't it?
What?
You are Nokma. You are
Nokma.
Yes. So respondent number 5 is the Nokma.
No, my lord. Out here, the challenge was against all these residents, my lord. All these residents. There's Ranjan Sangma, who's the Nokma, Gongsan Sangma, Genjang Sangma, Kilpen Sangma, Medicine Marak, my lord.
How many Nokmas are there?
No, in reality, as of now, my lord, there's only one.
At that point of time, there are 5
At
Nokmas.
that point of time, 5 people were
They
made
were Nokmas.
respondents.
All of
They
them
were
were
made
Nokmas.
as respondents, my lord. They were made as respondents. The Nokma is only one, my lord.
No, you represented respondent 1 to 5, but then so far as the petitioner in this case is concerned,
He
he
was
was respondent number 5.
the petitioner in this matter, my lord, as far as it goes back in the 1989 case, my lord, this was represented by 3 people, the petitioners. 3 people were representing the Nokmas. Their representative Nokma from the Asil Aking, and 5 people were arrayed as respondents from the Sokadam Aking, including the Nokmas of both Akings.
So there is no dispute between the parties that this earlier litigation was between the parties who are parties there in this case.
No, my lord, there's no dispute to that.
Disputed.
No dispute, my lord. It is on record, my lord, that these 2 Akings were in dispute
Yes,
from
private,
that time.
private respondent, who is there?
Mr. Pulang is there.
Your Lordship,
Is it correct that that was the earlier round of litigation in civil rule number 744/89? The fight was between the same parties who are parties.
same parties, Your Lordship.
Yes. Okay. All right. Yes.
From the very start, no, there's been a dispute between these
So
2
matter
Akings.
was remanded back.
Remanded back, no.
Then what happened?
To be tried in line with the principles as interpreted in Dora Sama's case, no. Thereafter, no, by the next year 5, no, which is at page 52. The Assistant Settlement Revenue Officer, no, he directed that for the parties to be present, not for erection of the dips, no, of the boundary pillars, which is known in locally as dips, no.
So in the earlier round of litigation,
It was for the
orders
election of
which were in your favor, it was interfered with, and matter was remanded back.
Remanded back, no.
Okay. So you did not challenge that order.
No, my lord. We accepted that order.
Yes.
Because we were not happy, my lord, with the manner in which the the demarcation had been done. But we were agreeable to the survey that had been conducted.
So anyway, so then what happened? Thereafter, after the remand, then what happened?
Thereafter, my lord, by way of annexure 5, the Assistant Settlement Officer, my lord,
Annexure 5 is at page?
Page 52, my lord.
Okay. Yes.
The Assistant Settlement Officer, my lord, directed for all parties to be present, to present themselves on the 5th of April 2002 for erection of the dips, my lord.
Yes.
Erection of the pillars, that is, my lord. Why,
what does it say?
if I may read, my lord, the subject is dip erection. With regard to subject cited above, regarding your case, R.B. Chetri, Advocate Commissioner report, and EM member in charge revenue direction that the prop Gitok dip B will be erected. By this order, I hereby direct my officers to erect the prop Gitok dip on 5/4/2002. Therefore, you are hereby requested to attend the same along with the Maris on the fixed date without fail.
So
now, this notice has been.
Gitok dip is what?
My lord, prop Gitok dip is a boundary pillar that is placed at a joint.
That is we understand, but then the remand was for the fresh adjudication.
Fresh adjudication.
What happened? Where is the adjudication?
There was no adjudication, Lord.
And then there was
the Assistant Settlement Officer just sent a notice saying that the prop Gitok dip will be erected on such and such a date, Lord. As against this, Lord, at next 6, if your lordship has it.
Okay, then
against this notice, Lord.
What you have impugned? This notice is
I'm not impugning all these. I'm just bringing on facts, Lord. Just the facts. I'm just on facts now. I'm just taking my lords on the facts.
Okay, then
I will come to the point of law.
Yes.
Then again, my lord, in
next page, what you are saying?
Annexure 6, my lord. Against this letter, an objection was placed, my lord.
The objection is at page?
Objection is at Annexure 6, page 54, my lord.
Okay.
Annexure 6, page 54, my lord. Against this notice, my lord, the members of the Asila King represented by the Nokma then, they sent a letter to the assistant, they sent a letter to the Assistant Settlement Officer.
Is objection by you?
No, from the other side, from respondent number 4, my lord.
You did not object to that?
No, we did not object. They were aggrieved by it, they went forward. They said, no, we're not happy with it, kindly postpone it.
So, this Asila King is respondent number what?
4.
Here?
No. Number 4.
Then what happened? What is the substance? What is the reason for?
Well, the objector stating that the matter had been directed by the Honorable High Court by order 20th January 2000 to be tried afresh in lines with the principles and guidelines as laid down in the Garo Hills Autonomous District Special Customs Usages Validating Act 1958 and as interpreted in Doris Sangma's case. That was their ground of contention.
Yes. Then what happened?
So we have nothing on that. Thereafter, the while on Annexure 7, the Assistant Settlement Officer went ahead and erected the hip and presented his compliance report of the same to the EM in charge land revenue of the GHADC.
Annexure 7.
That's at page
56.
56.
So boundary pillar was erected.
Erected, despite the objection by respondent number 4. That had been done.
So this boundary pillar was between which village? Between which villages?
The boundary pillar actually is at the joining point, at the meeting point of the Asil Aking, Sokadamgre Aking, and Rongrebolgre Aking. Now the contention here is from the side of the respondent before, where they have alleged that we have encroached upon the land. That was the reason why the 1989, in the case of 1989, in 1995, the High Court had directed for a resurvey to be conducted in lines with the map that had been drawn in 1929 by the then Deputy Commissioner of the Garo Hills. In 1929, a survey had been conducted by the then Deputy Commissioner. He had shown on the map, which is in Annexure 2, where the Prab Gitok should be erected. In 1987 and 88, there were fresh rounds of litigation between these two parties. Therein, in 1989, a fresh suit was brought before the High Court, my Lord, by way of Civil Rule number 744 of 89. In 1995, the High Court directed for resurvey. In that resurvey, they had appointed a court commissioner, for resurveying the land. In 1999, the commissioner had presented his report before the High Court, and that report stands unchallenged, and has neither been set aside by any authority.
Now this report which was submitted, how many rounds of litigation you said?
4.
This 4.
With the present one, not 5.
The judgment which you have pointed out just one, this is number 1.
That's the first one.
This
That's 1989. That's the first one. The first round of litigation before the Honorable High Court.
Okay. Then do we have to go into all those things?
I doubt that. If I may,
just then you take us.
If I may simplify,
the things which is relevant for the purpose of deciding.
Thereafter, there are another 3 rounds of litigation that proceeded till the High Court, including
on the same thing, that
erection of dips, then delay in the compliance of erection of dips, and all that.
Yes.
All these proceeded.
Your Lordship, to the High Court.
So
now,
all these occasions it was remanded back to the.
Yes.
Now, my Lord, eventually it culminated in an order that was passed by the EM in charge, which is at page.
What is under challenge in this case?
The judgment and order of the Chief Executive Member.
So that is the only thing which is under challenge.
Right, Lord.
Okay. Now where is the judgment?
Your Lordship has
28/9/2016, isn't it?
2016.
Yes.
My Lordship.
Where is that judgment?
That's at Annexure 17, page 96, my Lord. Prior to that, if I may request my lords to have Annexure 14, my Lord. It is important for this matter, my Lord. Annexure 14, page 84.
Yes.
My Lord, I would request my lords to kindly note the date, my Lord. It's 22nd July 2015, Lord. 22nd July 2015, Lord. That's the day on which the revenue executive member in charge had passed his judgment as against the matter pertaining to the erection of debts. Against this, they proceeded by way of an appeal to the court of the chief executive member. That is annexure 15.
This is the EM. Then you are taking.
This is the order of the EM.
Yes.
Then we have an appeal before the CEM. Annexure 15, page.
You have pointed out to the date.
The date.
What
the date.
for? What is the relevance?
There's a relevance, man. There's a relevance.
And then come to the next is
Annexure 15.
15. Page.
Page 87. Man.
Page 89.
89, yes. Man.
No, this is an appeal, memo of appeal. Where is
memo
the,
of appeal? Exactly, my lord.
Where is the order?
My lord, kindly allow me just to take your lordship.
No order has been passed.
Order has been passed, my lord. And for the understanding of the order, my lord, why that order stands is null and void and should be set aside, my lord, we need to go through these, my lord.
But that is okay. That is so far as the merits of your argument is concerned.
Lord.
But then we want to see whatever is impugned here. Now, whether the CEM has upheld the order of EM.
No, my lord. Yes, set aside.
Yes, set aside.
It's for that reason, Lord, that we are before.
decision was in your favor.
In my favor.
Now, see, be clear to that thing. You just say
EM's decision was in my favor.
Until unless you make this clear-cut submission, this court will not understand you.
EM's submission was EM's in my favor, Lord. And then they were aggrieved by that. They went before the CM, Lord, by way of this appeal.
You have coming as reversal, isn't it?
Right. Lord. Setting aside the.
Now, where is the order of the CM?
The order of CM is under challenge, Your Lordship, before this court.
That is what you see. This court wants to know it. See, instead of going here, there.
No, my lord.
Yes, Your Lordship.
We should be.
Well, Your Lordship, we kindly peruse the order of CM.
Is it page 96?
28/9/2016 under challenge before this court.
28/9/2016.
That is Annexure 17, Your Lordship.
Page
96.
96, man.
Yes. It's not page 97. Earlier you said page 97. It is page.
No, it's 96, man.
Yes. Let us see what is the order here. Yes, please go through. Let us see what is there.
Should I read?
You are the respondent here.
I was the respondent here, man. Should I read, man?
Yes, definitely. We have
the case leads to the boundary dispute commencing from the year so-and-so to so-and-so. The people of Sakadam agree, particularly the respondent of this case, forcibly started encroaching the Jhum cultivation to the Asal King, claiming to be the own.
You read very fast.
I apologize.
You read very fast, then you not understand it.
I apologize, man. Own part of the King and the respondent have removed the boundary dips at the Mengo Jabia Gitok and Prab Gitok and claiming to be the Badwa Gitok as Prab Gitok before the court illegally done with malified intention. The Honorable High Court in WPC number 6 of 2012 in an Aking case of Asil and Sokadam have been remanded back to be tried afresh by the Honorable High Court, order dated 27/9/2013 and directed accordingly to be followed the lay down principles in the act as interpreted by the High Court, Honorable High Court in the case of Dore Sangma and others versus Chief Executive Member GHDC Tura and others reported in 1988 Volume 2 GLR 120, whereby the fundamental principle of judicial procedure in deciding the dispute between the parties are framing of issues, that is the point of dispute between the parties. This, my lord, has been copied from the judgment of 2013, Lord. Opportunity to lead evidence on the issue to the parties by oral as well as to take documentary evidence, hearing of the parties themselves through their lawyer if engaged for deciding the disputes between the parties. The District Council, that is the EM in charge land and revenue, has to see what the real dispute between the parties as directed are found out by the court upon perusal of the respective pleadings, and the case has not been conducted in compliance with the procedure laid down by the Honorable High Court while interpreting the provisions of GHDC Social Custom and Usage Validating Act 1958 as such. It is submitted by the present appellant that the trial of the case stood vitiate since the matter was heard only on issues of law point and nothing else, but the EM in charge land and revenue in this instant case passed final order based on the commissioner report by RB Chetri advocate, which was challenged at the time and again. Honorable High Court issued the direction to try the case afresh in WPC 6 2012 2. But executive in charge land and revenue totally ignored the vital documentary evidence on record that the boundary of Asal Aking and its neighboring Sokadam Giri Aking as per back as 19 March 1929 by this then Deputy Commissioner Garo Hills. The map of boundary description of the Asal Aking start from the confluence of the Rongrong River and the Banjir River towards the east, and there's Asal which flows down and meets another stream called Mangojabia stream up to the source of Mangojabia, and from this source of Mangojabia stream 108 cubit away in distance is the Prab Gitok, and straight cross is the dip of Badwa Gitok. The Prab Gitok is the dip which is the meeting place of the three Akings, namely Asal Aking, Sokodam Aking, and Rongri Bogri. On the western side of the Mangojabia is Asal Aking, and on the eastern side runs the boundary of Sakadam and Rongri Borgri Aking. In respect of the claim of the Asal and Sokadam Aking Nokma in regard the boundary dispute, Sri W. D. Shira in its order 25/7/2015 directed the Revenue Officer Sri P. R. Manak to be assisted Mozadar in presence of local and neighboring Laskar by issuing by the date of erection of pillars to be concerned Aking and parties with respect to Laskar dispute to the right along with the Revenue Officer and to submit the report as early as possible, but this order has never been carried out till today, though the parties are agreed for erection of these at the proper exact of point of location as per back as 19th March 1929. This is the report of the Deputy Commissioner then, which has been relied upon by R.D. Chetri. Erected by the then Deputy Commissioner of Garo Hills. As briefed by the appellant petitioner, I pass the order that the impugned order, my lord may kindly take a note of this, 24/7/2015, my lord.
Yes.
My lords may kindly note the date. Passed by the then executive member in charge Land Revenue, GGC, in writ in case number so and so and so, hereby set aside and alter to make the absolute to erect the dips as agreed by the parties, which is a matter of record, and pray by the parties with particular reference to the location of Prab Gitok, which is admittedly at the meeting place of the Asal Aking, of the three Akings, Asal, Sokadam, and Rongri Bolgri, and Menjojabia, and Asin stream, as map prepared on 19/3/1929 by the then Deputy Commissioner Garo Hills with particular reference to the location of its finality. I dot order that the then executive member in charge Land and Revenue JHDC to take the matter with immediate effect accordingly, send back these records for immediate steps in order to speedy the matter according to norm and principle laid down therein, and to give its findings in accordance with both the parties. For the aforesaid reasons, this court is aware of the view and the factors to be considered as agreed upon by the parties orally and written to erect the dips as maintainable according to the above extent. In the result, the prayer of the erection of the boundary dips to be erected accordingly at the location stated here above herein before. Case stands disposed of. As to cause, parties will bear their own cost. My lord, going through this entire judgment, my lord,
that is the order of remand again.
Order of remand, Lord.
Absolutely, order.
My lord,
matter was remanded back to the EM.
My lord,
yes,
is it what? That is the I can only presume, because what has been written here is a little bit confusing, Lord. It can only be presumed that he sent it back, Lord.
Now, then executive in charge. Then what is means by then executive in charge?
It has to be the EM, Lord.
No. What is there? You mean by then EC?
It has to mean the executive member in charge, Lord.
So it means if that then EC was no more there, their matter could not have been taken up by any other EC.
No, that I think
what
that
does
doesn't.
it mean? Yes,
I think it is a lack of the command of the language, Lord. I think it exactly.
Says, kindly read it here.
I dot order the then executive member in charge Land and Revenue GHDC to take up the matter.
Immediate effect accordingly. Send
back the case record for immediate step in order speedy according to norm and principle laid down therein, and to give its own finding in accordance with both parties.
So this earlier order is set aside and then it is sent back again.
I think so, Lord. That's
yes. So what is that is what this court is getting. If it is
yes, Lord.
If it is not there, then you tell us why.
No. That is what is emerged from here, Lord.
So you agree also that this is a matter which was sent back. Okay, then what happened?
Lord, now this court will appreciate any order, if any order comes before this court, Lord, when this court states that order, it has to mean that order, number one, Lord. That order has to be in existence, Lord. If an order has been passed, if I challenge an order that is dated today, Lord, the 15th of October 2024, it has to be in writing and on record, Lord, that that order has been stated, Lord.
Yes, definitely.
Now, my Lord, will appreciate the order that has been stated is set aside is 24th of July 2015, Lord.
So that is one omission.
That is one.
The date has been wrongly.
And sitting as a judicial body, my Lord.
What about the case number?
Sitting as the case number, my Lord. To my understanding, my Lord, the case number.
Revenue 143 SC of 2013. Is there any
2013.
mistake with this number?
Let's check. No, my lord.
So your first contention is that the date mentioned in the order of the CM is not the date on which the order was passed.
That's number one, my
That
lord.
is ground number one.
Number one, my lord.
Yes.
Number two, my lord, if your lordship has the memo of appeal, my lord. Annexure 15, my lord.
Is it not, Mr. that it can be ignored by saying that it's a clerical error?
My lord, by judicial body, my lord, if
Is
your
there
lordship...
any other order in existence on that day? Was there any order?
No, my lord. To my knowledge, there's no such order, my lord.
It's a typo error.
3 to 7. Anyway, just if you make a better point, that will be.
My lord, another aspect, my lord. If I'm before your lordships by way of a writ, your lordship has to be divested with that power under the constitution for me to ask for a writ to be enforced, my lord. Can I now go before sessions judge, my lord, and plead that I claim for relief by way of a writ, and the sessions judge will grant me that relief, my lord?
No, where is the question? You want to say that improper or illegal exercise of jurisdiction?
Exactly, my lord.
Who was resorted to illegal exercise of
My lord,
jurisdiction?
if your lordship has page 91, my lord.
Page 91.
My lord. The last paragraph, line number 5, my lord.
Yes.
If I may read, my lord.
This is what? This is a part
This
of
is the prayer of the appeal, my lord.
So then you tell us that this is
This is
a
a
part
portion of the prayer, my lord.
This is an appeal. It's a memo of appeal.
It's a memo of appeal, my lord,
Yes.
as I said.
And then para 4. Page
Last
91.
para, point number 4.
Yes.
Line number 5, my lord.
Just read the paragraph. What is the problem? That your appellant.
That your appellant states that the action of the respondent is violative of the Aking and wrong re Aking in GTC revenue so AC 2001-2003, my lord.
Yes.
And this is no way in connection to the instant case that was cited by the EM charge, my lord. And commences fresh proceedings in accordance with judgment dated order 20th-1-2000, my lord. Which again makes no sense, my lord. Passed by the Honorable High Court.
Just a minute. Just a minute. Very, very difficult to understand. You see, like that your apparent states the action and violative of the Aking and Aking. In GTC review number means what? The case number.
Case number, man.
This refers to the case number.
The first case number.
Yeah. Now this number is
under
wrong.
appeal, man.
This number is wrong.
That is also wrong, man.
What is the correct number?
Correct number is 2013, man.
Not 2001, 2003.
No, man. Your Lordship had correctly pointed out.
Okay, then this is one thing. And the compensation in accordance with the judgment and order dated 21/2000.
Right, man.
There is no judgment of 21/2000.
There's an order of the High Court, man. There's an order of the High Court, but not a judgment by the EM, man. And thereafter, they proceed passed by the Honorable
But then what is wrong in it?
Lord, what they're asking for is not in existence, Lord. At the very start, they asked for being.
See, judgment and order dated 21/2000 is not in existence.
It's not the order of the EM, Lord. The order of the EM is not that, Lord. It's 22/7/2015.
According to judgment and order. No, you see, it refers to only High Court order.
Only High Court order, but thereafter, Lord, they're asking, Lord. Now.
No, it is not what you are see. Like it doesn't. The meaning, this line doesn't portray the meaning which you are trying to say. See, in accordance with judgment and order, it passed by the High Court. So what is the problem in it?
No, Lord. And thereafter, Lord, the prayer made by them.
Yes.
And or why writ in the name of certiorari be not issued, quashing and setting aside the order dated 22/3/2002, 23/4/2002. There's no such order, Lord, which they are asking for. The order in question right now, my Lord, is 22/7/2015, Lord. They are asking for a writ of certiorari and or any other writ for quashing order 22/3/2000 and 22.
You see, this actual order was passed on
22/7/2015. Right, Lord.
The memo of appeal aside order dated 24/7/24.
And the appeal memo of appeal, my Lord, the memo of appeal at the very first instance asked for being aggrieved by an order dated 24/7.
So you want to say that there was no challenge to that order dated?
There's no challenge, my Lord. How can they stay an order, my lord, which is not even in existence. How can they remand back a file, my
Have
lord?
you raised that point before the CM?
No, my lord, we have not raised that, my lord. We have come straight before the High Court, my lord. Because the next high authority will be this High Court, my lord. My lord, how can you raise it before him when that order, very order is not even in existence, my
When
lord?
CM took up the matter, was it pointed out?
We have pointed out, my lord.
Then
I'm very
is there
grateful
any
to your lordship.
reflection of that in that order, in the impugn order?
No, my lord, that's the order of the CM, lord. He says in his order, my lord.
No, if you have at all raised that plea,
We have
before
raised,
CM,
no. We have raised.
was
But
it
we have,
recorded there or no?
it was not recorded at all.
Is it your case? Have you taken a ground that you have raised that plea and it was not recorded?
Yes, my lord, we have said that.
Where?
Not in pleadings, my lord.
In this, before this?
In this.
Okay, we'll come to that.
We had even raised it. We had even raised it.
This is the ground of this thing. And what else?
Lord, we had even raised it at the.
You want to say that in fact there was no challenge to the order dated 22.
Lord, a court that is not vested with writ powers, Lord, has utilized writ powers, discretionary powers, Lord.
This cannot be. This cannot
Stay,
be.
Lord, how can?
This is kind of an argument. You see, like we can understand. We can understand. You see, like you understand the level there. So mostly rural people, rural background, probably. But then it is not a case that where CM does not have the power to interfere. He
Yeah,
has.
they have the power.
Whether by way of issuing writ or not, that is not the question. If he has the power, he has access to it.
Well,
Did he
but-
say he did not issue any writ? Did it say I hereby issue writ of Mandama Society? He did not say so.
Here, my lord, he says, as prayed for by the appellant petitioner, I pass this order impugn dated 24/7 passed by the EM in charge land revenue to in rate case number so my lord.
If I can just intervene, my lord, this is the ground which my learned friend is reading, the ground of the appeal. And what was the prayer? The prayer is on page 92, my lord.
Achha, this paragraph 4 is the ground.
Is the ground, my lord. Now, my lord, may kindly come to page 92.
Mr. Ray will
My
help you.
lord.
If he
I'm just putting it
basically
out.
place it wrongly, then definitely this court will not.
I'm not placing anything wrong, my lord. I would like to say that, my lord. They have asked for relief for, they have stated they are aggrieved by an order that is not in existence. They have prayed for relief for an order as against an order that is not in existence. They have brought forward a case number that is not in existence. They have asked, my lord, for issuance of writ of certiorari, which that court, the appellate court, has no power, my lord. Thereafter, the appellate court accepts, despite of us coming forward and explaining, my lord, by way of a show cause, that this is not maintainable, the appeal is not maintainable, my lord. The appellate authority went forward, my
When
lord.
this appeal was filed?
This appeal was filed in, that was in 2015, my lord.
And when did you get notice of the appeal?
Notice of the appeal, my lord. We filed our show cause, my lord.
You filed your show cause?
We filed a show cause also, my lord.
Against the appeal?
Against the appeal.
Just take us to your show cause. When did you file your show cause?
Annexure 16, page 94, my lord.
Yes. And what is your where are the pleas by you?
The plea is taken by us. The plea is taken by us. There is no legal or factual ground, my lord, for the appeal against impugn order, judgment order.
Which part you are reading?
The first point, my lord, page number 6, annexure 16. 94, point number 1, annexure 16.
Legal or factual grounds for appeal.
There's no legal or factual grounds for the appeal, my lord. You have stated that, my lord. Legally, there's no.
Over the ground, but then you have never said that there are those things. There is no such order and all those things.
No, that we have not said, my lord, but we have placed that the order is dated 22/7/2015, my lord. You have stated that. There's no legal ground, no factual grounds, my lord, for them to come before by way of this appeal.
Did you challenge the maintainability of the appeal, saying that there is no such order and there is no appeal can be maintained against non-existent?
You have said that also, my lord, that the grounds of appeal number 1 to 9 are not correct and therefore denied, not by us.
Where is that?
That's a point number 7, my lord.
You have not taken any ground. You have not taken. You cannot improve it. Where is the question of interpreting in the other way?
Not interpretation, my lord. But the very first line itself says that we have stated, my
challenge
lord.
is confined to the ground. What this court is asking you a question is that where is your specifically with regard to the maintenance of the appeal?
Point number one, my
On the
lord,
ground that
I'll still state, my lord.
there exists no such impugn order.
My lord, point number one, I'll still state, my lord, that there are no legal, my lord, or factual grounds for the appeal, my lord.
That is the thing.
That is the,
Okay, and then what else?
not to the best of their ability there, my lord.
What is the other thing? What is the other?
Lord, we've also said that,
Which other paragraph? What is the other objection? What is the other ground?
my lord, we have stated that both the parties had conceded before the EM to allow him for passing the final order, my lord. We had submitted our written arguments, both the parties. We have an issue that had been framed, my lord. Both parties have been heard. The records were looked into, my lord. Day after the EM had right the order, my lord, of 22/7/2015, my lord. So there's no
Order of
illegality.
22/7. Oh, there is order.
There's an order, my lord. There's no order of 24/7. my lord.
Now, see, so far as your Shokos is concerned, it doesn't specifically say anything about those things.
No, but we've denied, my lord. We've denied. We've categorically placed before him that there's no legal and factual
Anyway,
aspect.
but then you have not raised any specific issue with regard to the material of the appeal.
My lord,
On the ground that there exists no such impugn order.
right, my lord.
24/7.
But if that be taken, my lord, on the other side also, neither have they given a correct date, nor have they challenged in a correct manner. But we have at least, my lord, put forth that there are no legal and factual grounds, my lord. Right?
That is okay. See, legal and
that gives
factual
ground for the
is a
present
different
appeal.
thing. It's a different thing. It concerns merit. It concerns merit.
If it
Doesn't
concerns
go to
merit,
the-
not then the
doesn't go to the question whether there exists any impugn order or not.
right, my lord.
Now, the case which you are placing before this court is that,
There's no impugn order,
that
my lord.
in fact there was no impugn order,
And
as well as by the respondent.
and the CM has stayed the operation of an order which is not even in existence, my lord.
So in
And in
Shokos-
essence,
okay, that
remanded back the appeal, my lord.
Then anyway, what else you want to say?
My lord, I feel, my lord, I may submit that violates the entire judicial propriety, my lord. And for CM to act in such a manner, my lord, is unbecoming, my lord. Be that as in me, my lord.
See,
He sits
which
near-
manner you have not raised all those points before him, so there is no question of him
We have raised,
dealing
my
with
lord.
those things. Those
We have reason. But then his entire findings, my lord, he says, as prayed for by the appellant, my lord. That is his order, my lord.
That is okay.
He does not listen. In fact, he just copies the entire report, my lord, relies on 1929 map, my lord, drawn by the deputy commissioner, which had been relied upon by R.D. Chetri, which is disputed by respondent before, and then comes to this order, my lord, which we are assailing here.
Now, can it be ground for interference in direct jurisdiction when it comes to appreciation of a document?
No, my lord. They'll be at the court of first instance, my lord. Not even at the appellate stage, my lord. It will be only the court of the first instance, my lord, which can appreciate facts, my lord.
What is the order passed by EM?
Order passed by
This
EM.
court has not got very clearly your case. It is something kind of a,
EM order is in
My
page
lord,
84.
Page
my lord.
84, my lord.
84.
84 and extra 14, my lord.
this order was in your favor.
This order was in my favor, my lord. Now, all the while, my lord, cases have been cropping up on account of non-compliance and non-adherence.
Do you have a typed copy of this order?
No, my lord, this is the.
Then
it's-
how
it's
do
typed, my
we
lord.
read it? See page 85. Half of the words are cut. Lines are not complete.
I apologize for that, my lord. I apologize for that, my lord.
No. Then how can we proceed? Do you have to go through? See, not only this page 88 also. Then you are not supplied a type copy of this page 87 also. Oh, Mr. Thank you. What a wastage of time.
I apologize, my lord.
No, but then, how will go through this? Yes, Mr. Day, you have a better copy.
No, my lord, the same copy has been enclosed to us also.
This is very difficult. It seems see like page 85 there seems to be this See, it's
85,
very
so half
difficult.
of the word is.
You cannot construct sentence by applying sense also. You have to get a type copy.
Right. I apologize for that.
When you will submit? This is, you should have, see, this is not a wastage of time.
Abscess not on my part. I apologize for that.
Hard. Grant the counsel for the parties at some length. From the perusal of documents on record appended with the writ petition, it is found that the judgment and order dated 22/7/2015 passed by the executive member in Cardiff District Council, Autonomous District, Crown is Autonomous District Council. Is not legible. You have to type out the whole thing. It's not a very big thing.
No.
The learned counsel or the petitioners prays for grant of some time to supply the type copy of the said judgment and order. What is it? The learned prays for some time. Is it? Before the matter is taken up for final hearing. Prayer allowed. When can you do it?
Lord, I'm praying for 3 weeks, Lord.
Such a small order.
No, Lord. It's not about the order. I'll have to ask for the original to be brought, and the person is located in a very far-flung place.
You just say as prayed for. Do not say prayer allowed. You say, Acha, just say prayer allowed. List this matter after 3 weeks. This court will forget again this whole thing again by 3 weeks.
I'll try to recap the next occasion.
You sum up, you see, like your points and just give it. You just refer to the order of the EC, EM and CM, and just say what is wrong in it. As
Absolutely.
you pointed out that certain points with regard to the dates and all. And the other grounds which you are saying that 1929 document, which was relied upon by the CEM, was in fact disputed by the other side.
In fact,
Is it
that,
what you say?
that right, no, that
So you want to
1929
say that if
had
that
also been.
document- just a minute. Just what this court got is that if that document is disputed by the private respondent, how the CM could see, then we have to show us where they have disputed it specifically.
I'll
These
take
are
your
the
lordship.
things we have to
I'll
distinguish.
take,
So
I'll
if
take
you
your
make
lordship.
specific,
I'll
you
take
can
your
cut it
lordship.
short and finish the matter in short time.
Right.
Instead of traveling here.
Right.
Yes.
Rajman.
Item number 6.
Obliged, Lordship.
Yes.
Please, Lordship. On the earlier location, Your Lordship, the record was called for Your Lordship, and then the lead counsel for the GHDC, they have submitted the report. I have gone through the report also, Your Lordship. Now, my Lord, before I come to the report submitted by my learned friend, I would like to just make a small brief of the case And
Yes,
just
please.
wanted to
Just refresh the mind of the
yes,
court.
just
What is it?
now the case of the petitioner here is that the particular this Adugachar Akung was in existence since from 1969 that 1930,
You are the
1933.
petitioner is?
I'm the petitioner.
Petitioner is what?
Petitioner is the Nogma
Of?
of that Adugachar Akung.
Okay. Adugachar.
Yes, Adugachar. As per the GT report, Your Lordship, since from 1933, that Nogma was approved, Akung was there, that in existence. I will just repeat and I will come to the.
Yes.
After that, Your Lordship, since that has been in existence since 1933, but suddenly in the year of 2009, that Adugachar, yes, the Adugachar Akung was cancelled. Since from 1933 has been continuously we are in possession, and that was recognized. And suddenly, after for so many years, after a gap of so many years, in the year of around 2009, the particular Akung, the petitioner Akung, Adugachar Akung was cancelled. In that
After 76 years of existence.
yes, absolutely. Then in that cancellation,
It is cancelled.
cancelled.
Now, is there any provision of law to cancel an Aking? Is there any provision in law
there is
to cancel an Aking? Now, who cancelled the Aking?
There is a CEM of JCD, EM of JCD.
He has the power to do that.
He has no power, and there may be the
No,
procedure.
are you your case here is based?
Yes.
Whether you see what is the case? What is the main points you are raising here?
Well, yes,
Are you
Lordship.
challenging the very authority of the EM?
Yes.
Cancel the thing.
Yes.
They cancel the Aking.
They cancel the Akung. Lordship,
what is your case?
Lordship, let me just
authority?
Lordship, let me just complete my submission, Your Lordship. Because then I think after
Okay,
completing
please,
that
please.
your query, I think I will.
Yes, please.
Yes. Now suddenly, Lordship has asked me whether he has the power to cancel or maybe if
No,
there.
anyway, you proceed
Yes.
your way.
Now what is my case was there, since from 96 years that for about 76 years that Akung has been existing, suddenly in the year of 2009, without notice, without any petition from any other from any counter, even from the private respondent, not from anybody, that Akung has been cancelled, saying that it was merged with the Magufara Akung. To that effect, after cancellation, prior to the cancellation, there was no notice issued to the petitioner, neither any, there was not even a petition from anybody, even from the private respondent. It was just cancelled, and later on we come to know that our Akung, the petitioner Akung, was cancelled by the JCTC. Then we file an appeal, and after that we filed
an appeal
before the CEM of JCTC, saying that Akung was cancelled illegally without issuing any notice, without giving an opportunity to show cause. Nothing was there. Then
you did not challenge the authority of the EM.
No, we did not challenge.
But then your thing was that no notice was issued.
No notice was issued.
No opportunity was given.
Notice, maybe he has the power. He has got the power, but power only on if their law permit, then they can cancel.
What is the law then? What is the law which allows EM to cancel Aking?
No, it depends on the circumstances. Suppose if there is any complaint that that particular Akung was not in existence, they will go through that and then. But the proper procedure.
So that power is there.
Yes, power is there.
The
procedure has to be followed. That is the thing. Okay. And after that, numerous litigation was filed, and finally it was.
Wait, just a minute. Then you raised an objection.
Yes, we raised the objection.
And then what happened?
Then that cancellation order was set aside. Before that,
by the CEM.
By the CEM.
Yes.
Thereafter, other party have come before the High Court.
Yes.
It was remand back again.
Remand back to the
EM. Again, the EM has.
It means the EM order also was set aside.
Set aside. And then, in short, Lordship, there is a lot of EM remand back, come back at least twice.
How many times?
This, I think, this is the third time, Lordship, if I'm correctly remember. But I stand corrected. But third time, this is the third litigation after remanding. Now,
third litigation before High Court.
Yes, Lordship. Now, my point is, Lordship. Now, I will just make it in a short. Now, on the earlier occasion, this matter was heard at length, and then the Lordship has called for the record, Your Lordship, and then they have produced the record. GHDC have record. Now, I'm only on the record produced by learned friend by the GHDC, and before coming to the report submitted by the JJDC, on the earlier occasion.
See, you have, but then you have cut short. You have not given us the detail. You see, now see, after you approve CEM, the EM's order was set aside.
Yes.
Then the other side approves the High Court.
Yes.
The High Court interfered in the entire matter. Matter was remanded back to EM.
Yes.
Now what happened thereafter?
Thereafter, the impugn order, finally the CEM has passed an order.
Wait. What happened first in EM's court? EM before EM.
Before EM, he has upheld.
After the first remand by the High Court.
Yes.
Then EM, what he did?
EM said that cancellation of Akang was done correctly, means the
So you upheld the decision of.
Yes.
Okay. Then you challenge it before CEM again.
Yes.
Then what CEM did?
Then CEM also upheld the order.
Then you came to High Court.
You come High Court. High Court.
High Court again remanded.
Again remand back.
So decision, okay. High Court again remanded back.
Remand back.
On what ground it was remanded back?
High Court remand back with that the procedure has to be followed, and then the document has to be examined.
Okay. So it was.
Then that was.
Now we are in the third round.
The third round.
Now after that remanded, then again what happened? EM again passed the order in your
passed
favor.
An order and
your favor.
No, in their favor. Again the CEM, that final
CEM said then again upheld.
Yes, upheld.
Now you are before this court.
Yes, Lordship.
Now what is the ground then?
The ground I have stated here that.
Is it correct, Mr. Mohanty?
Lordship, my lord. Yes, my lord. Before before my learned.
Something is missing. I'll fill up.
Yes, before.
We should get the correct.
Yes, Lordship. Before the senior make a submission, let me just complete my this one, Lordship. Now I have stated my case before this honorable court that EM and the CEM, learned CEM of GHDC, my submission before this, they have never followed the basic principle which was cited in that given in the Dore Sharma case, that framing of issues and discussion and the leading of evidence.
Can you see the last order of the High Court by which it was remanded back?
Yes, Lordship, that.
The last order, the last. Where is that?
This is 2016.
Where is that?
That is in Annexure 18.
Page 147.
147, yes. 147. Page 147.
The order starts at page 144, isn't it? Page.
Yes, that is start.
Yes.
But 144 is start. The content, the operative, it start from 147.
Yes.
Mr. Kinjing Lanet, Senior Counsel, assisted by Mr. Petitioner Malay Counsel for and on behalf of the petitioner who submit that in spite of the judgment and order passed by the Honorable High Court dated 27/05/2013, passed in WPC number SH179/2013. The respondent in violation of the said judgment adopted a different methodology which is not acceptable. Learned Senior Counsel also further contended that the record of the Akang land in question is available in the office of the District Council. So they have to decide the matter on the basis of the record available in the office after giving opportunity of hearing to both the parties. So necessary direction may be passed. On the other hand, Mr. Day.
This is a writ petition. This is not a writ appeal, isn't it?
No. Yes, this is the writ petition only, my lord. Learned Counsel for the respondent JHDC submit that they are taking step only on the basis of the judgment and order given by the Honorable High Court refer above, and they are not including anything new.
So your grievance was that the documents which are available in the office was not taken into consideration.
Yes.
Now this court found that order
to
be wrong, interfered, and remanded it by passing a direction that the GHDC should take into consideration. Isn't it?
Yes.
But then this order has made a remand to the EM or CM?
It's going to be reasonable. This one remand back to the EM because after this, the EM has taken up the matter.
No, but then say supposing if this court had interfered only with the order of the CM, then EM order remained, and then the respondent uses the direct to dispose the matter. What is meant by that?
Judges respondent are directed to dispose of the matter on the basis of the document and record available in their office, and therefore, and after giving full opportunity of being heard to the parties.
No, by this order, what was set aside? Then nothing was set aside. Was a remand possible without setting aside?
However, Lordship, though nothing has been set aside.
What would be the interpretation of this then?
Yes, of course, no order is set aside here. But then, Lordship, that in meaning interpretation that the EM, while taking up the case, has to consider the document submitted or adduced by the
Why
parties.
EM? It could have been CM also. This earlier order passed by the writ court doesn't specifically say which order has been interfered with. It's a respondent GHDC. Now EM also is a respondent GHDC, CM also is a respondent GHDC. The one is the original authority, another is the appellate authority. Now who would decide?
Now, after remanding, Lordship, it was decided by the EM.
It was sent back to the EM.
Yeah, Lordship.
Now EM passed an order.
Passed an order.
And then CM again.
Again.
And nobody raised any objection with regard to that.
No, before the EM.
Mr. Mahato, what is happening? We do not know.
What is happening actually, that's why I said missing link is there. EM interest when it was in 2013 that order, 27/5/2013 when Justice referred the matter to the EM interest. Then when EM interest wanted to take up the matter, then they give some petition there. They are not happy with EM interest. When they against that order, they came before the High Court, asking strictly to follow the order of 27/5/27. That's right. And that order is being followed on the basis of the record available.
So as per the 27/5, the matter would start from EM.
Yes. That's right. That's what the issue is.
So we'll have to interpret this order by taking existence of another order and assumption.
2013. In fact, they challenged me before this High Court against the what order?
Was it not proper? You see, after the 27/5/2013,
yes,
some orders were passed, isn't it?
Yes, yes.
Rightly or wrongly, and those were, you see, like challenged before in the WPC number 2016.
Yes.
So was it not proper to set aside those orders?
It should happen. If something wrong should happen.
So
but
that is what we do not understand. How come it has not been pointed out? Because normally, if there is order of remand, the law says that impugned order has to be set aside.
That has to be set aside. But nothing has been set aside. Here, what happened? Your Lordship will see at page 140. 140. That is a CM's order. If your Lordship will look at page 140. That was under challenge.
Before CM.
This passed by the CM.
Anyway.
No. What is the point that why they didn't set aside? Probably this is the reason. I'll tell. There is no order passed. Actually, CM said follow that order of 2013 passed by the High Court. Against that they came. First, that I'll come into that. Before, please let me just finish. Since
I have not complete actually.
No, you'll have time. Your Lordship will see, this is the order initially to 135 page. What EM interest is wrong. I'll just come into that. Why he has come again the High Court before Justice has sent that order. This is ordered at 2/6/2015. Passed by the EM interest.
Page 135.
135. NHS 16. Page 135.
No, things becomes.
Lordship got that? Page 135.
Yes, 135.
This is the order date 2/6/15. Your Lordship. Heard both the parties, learned counsel for the opposition objected to the continuance of the present proceeding in view of the order dated 2013 pass Revenue Appeal number 13 AC 2010. The learned lawyer of the petitioner has drawn my attention to the order dated 27/5/2000 passed by the Honorable High Court of Meghalaya in WBC number Swenso, Nikmi Sangma versus GHC and others, including the present OP. In this order, the High Court has clearly stated the order dated 22/10/2009 passed by EM in charge revenue, and also the order dated 15/3/2013 passed by CM Tura in GHADC in Swenso appeal. The OP has erroneous mentioned the order dated 15/3/2013 as order dated 15/2/2013. The Honorable High Court has further directed the same order that the EM interest revenue GHC shall decide the respective claim of the parties appraised, giving full opportunity for putting up their respective case. In view of the above, the order is not ambiguous. I find no merit in the submission of the learned counsel for the opposite party. The case will proceed as per the direction of the Honorable High Court. That High Court, 2013 order. Against that, they were non EM interest appeal. Then EM interest wrote what? Your Lordship will see. On 14/6/2016, that 140 page.
Page 140.
140. Lordship, may I read it? They heard both the parties, the last paragraph. On perusal of the record, it is observed that the Honorable High Court has clearly stated the order date 2012/2009 and 15/3/2013. That way by Akim was cancelled. That said that the Honorable High Court further directed the same order that EM interest, land and revenue Garhills Authorised District Council would decide the respective claim of the parties appraised after giving full opportunity for putting up their respective cases. The cases being remanded back to the EM interest, land and revenue Garhills Authorised District Council Tura for retrial after following the direction of the Honorable High Court of Meghalaya. No order is passed as to any cause. Case stands disposed. The appeal disposed. Against these two orders, they came before the Honorable High Court, whereby the order dated 26/8/2016 was passed. So the question of setting aside doesn't arise, Your Lordship. Am I clear, Your Lordship? Because there is no cause of action accrued to them. They don't want to follow the order of the High Court, which set aside the earlier order.
Then what for this High Court's order was passed?
This order was passed. Therefore, I don't understand how they came to High Court and how the Honorable High Court passed this order. That High Court therefore said again, respondent, last but one paragraph, 147, JSDC are directed to dispose the matter on the basis of the documents and records available in their office, and after giving full opportunity of being heard to the parties, strictly to follow the judgment order at 27/5/2013 referred above. What is wrong?
Now, CM order had already remanded the matter back to EM. So again, High Court again remanded back to
Again, even
what is
so
the
this was unnecessary
so
litigation.
that was basically unnecessary.
Unnecessary
kind of
litigation.
Anyway,
That's why
this order is inconsequential. Matter goes back to that 2013 order passed by the High Court.
As per the 2013 order.
Yes. 2013.
For that only.
Lordship.
And in fact, all the
Now, what is the orders which are under challenge?
Lordship, before I come to that, Your Lordship, because this matter was heard earlier before to that effect, the order 24/06/2024 passed by this court. Your may I just praise this court because this is now this hearing was continued to that order only, Lordship.
It seems matter will take time. We'll come back after lunch, Mr.
As you Lordship.
Lordship, if that matter coming back, Lordship, it may come the next week, Lordship.
No, his part he already submitted.
No.
Me,
I have still more to say, Your Lordship, because I have some.
Has not got what is the order?
Lordship, there is an order, Lordship, because on to produce the record, because it is mentioned that it was hard at link, but then there is some query. That order was there on 24/06/2024, whereby this honorable court has asked directed to produce the record, Your Lordship. That's why now this hearing was just.
But that is okay. This court might have asked for record.
Yes.
That's okay. There is no dispute.
Yes.
Now, and this court has probably easily, if there is a lapse of time in between, the court forgets. So
yes, Lordship. I humbly pray because maybe on the next week, Your Lordship, or any time, because now today I have some appointment, Your Lordship. I really I humbly pray, Your Lordship. I have some engagement, personal engagement, Your Lordship, because
so that is case is confined to the
Yes.
contention that certain
Yes.
documents were
Yes.
not been
Yes,
considered.
that's
Only
right.
that. Now, you say that this has been considered. So we wanted to verify it. That is
Yes.
why the record
Yes.
was.
That's right.
Yes.
Only that.
So
Only that. And
yes.
to that effect, Your Lordship, I can just cut short at 151 page. Your Lordship, just 1 minute. I'm sorry, Your
But
Lordship.
then even then, Mr.
I
Sigma
know.
is not finished.
Yes.
We'll
Yes.
No,
come and-
whatever he said,
No,
his
we'll
own
finish on the
counsel
next
has
week,
said
Lordship.
that
I
do
will
not have any
complete my
document.
submission, Your Lordship. I will continue to that, Your Lordship, because yes, Lordship. I will try to satisfy and assist with my best ability to this court. Now we are only on the case record. I will just want.
See, Mr. Sangma, if there is a gap in between hearing dates, then this court forgets. It becomes total wastage of time.
Your Lordship, only.
No, Your Lordship has said
next week
every
or
now
any,
and then when
no.
hearing doesn't complete, he always goes on time.
No.
7 years has been dragged on this way.
No,
Your Lordship.
because there
I'm very
are
sorry.
cases not even 7 years,
interim order
more than
passed
5,
in
6 years are there.
There is no interim order.
There is no interim order there.
That is okay, then
No,
yes.
no interim order, but what happened due to pendency of this case, the land acquisition compensation pending in the collector already paid. Therefore, the collector is not releasing to my client.
That is
Just
not,
because of
that
this
is
case.
not,
And
not
please,
the
please,
subject
let me
matter,
say.
Your Lordship.
And he
because-
wrote a letter to the collector. A personal letter wrote to the collector. Due to that, collector is not
Your
releasing.
Lordship, because we are not coming for the compensation. Not
certain benefits.
No, not at all.
That
Not
is
at
why.
all. Not at
That
all.
is why Your
We
Lordship
don't have
is
any
dragging on the
benefit.
case
We don't
and
have
nothing
earlier. We have no knowledge regarding the payment of
No knowledge,
compensation.
no.
Is there any details of those things?
No.
No.
If
That-
there is
details
anything,
of
they can
this-
file an application, Lordship.
Wait, the court is asking some
Lordship,
questions.
Lordship. I'm sorry, Lordship.
You have details of all those things that
No,
refusal
that
of,
case was
collector-
pending before Honorable Justice Wanra and Mr. Samar withdrawn that case. That case pending because they came that Honorable Justice Dingo said that why do come before High Court? He said collector duty. How he can install the payment on his letter?
No.
P.T. Sangma wrote a letter there.
That is all right. So that is
So,
since it is not under
so
challenge,
therefore
you
he
will
is
not-
dragging on this case and
But
nothing
if
else.
you say that pendency
Please.
of this case is causing hindrance, then we will clarify that it will not make any difference. But then if you do not have the details, then there is no question of doing this.
No, details there.
Well,
Let them file to that effect.
Mr.
Any
Sharma,
misapplication.
We'll finish it next week. There's-
Yes,
Your
yes, we'll
Lordship,
finish it.
on the it may be put on record, Your Lordship.
If your Lordship can please to hear me in the afternoon, I can finish up this matter. Your Lordship.
It's up to you. Then if you agree, there is no
Your Lordship,
problem.
I'm praying, Your Lordship, because this is.
See, if you colleagues, if you are not ready to cooperate, see,
No,
this court-
I'm
this
cooperating,
court
Your Lordship.
accommodates everyone.
Yes, I'm cooperating, Your Lordship. Only thing is that
matters until and unless there is
I have
objection by any
I have
sitting.
waited also. I did not ask for time also, Your Lordship, but only because some difficulties, personal difficulties, my Lord. That's why I am asking the time, because these things happen, Your Lordship.
Yes. Mr. Dev.
I have nothing to say. Yeah, I'm learning from them.
Hello, Your Lordship.
Only thing
Make sure we should finish this.
Lordship.
case, Mr.
Only thing in this, my lord, which my lord has to decide is the letter or the record which you were saying, my lord, has not been considered by the appellate forum. That has been considered not, my
Not
lord.
by the appellate forum, both the forums.
Yes, yes.
His case is that the EM or the CEM has not taken into consideration.
Yes.
That is what he wants
That
to
is
say.
why I have compiled the entire record. I have placed before this honorable court. Because the record also is a very bulky record. That relevant portion.
No, but if he says one thing, that his Aking was in existence from 1993 till 2009, what is the reason which compelled you to merge his Aking with some other Aking?
Sorry, Your Lordship, I'll just interfere. No Aking. It is his own document says that this is a Sang. Sang means a village within our Aking. Even that has been, 18 witnesses has clarified this, Your Lordship. The record will say, I think record
will
Record, yes.
and they will get 4 times chances by the court to go for an inspection, they avoid.
No,
Your Lordship,
that is not
please,
correct,
please,
Your Lordship.
let me
I
finish,
will-
then you say.
Yes.
That's what they
Then-
avoid. And what happened? That the PT, another adjacent Aking said that my Aking number has been used by him in his Aking. How can it be?
Anyway, this, see, like
So-
if it comes to appreciation of merits and all, this court may not go into all
May not
those.
go. Therefore, I'm not submitting on that,
We
Your
are-
Lordship, since
Yes.
he is
We have
insisting
limited
that
scope of
the
judicial
existence
review.
of this Aking is a false, totally out and outright false.
I
I'll
will
prove from the
counter it,
document.
Lordship. I'll counter it.
I have the original Aking, this,
Yes,
I have the
Lordship.
document. Let him produce the
On
original.
on the last occasion, yes, I have make a submission regarding the image also. I will counter my learned, my senior was submitting. I will counter it, Lordship.
This is the 1929 document, Your Lordship, by Akin, Your Lordship.
We'll not go into
No,
documents
it is
and
there
all,
in the
sir.
records. We have submitted this
We'll
in the
not
record.
see what is there in the document.
Obviously, Your Lordship.
But then if it is certificate, if it is shown that these documents are not considered, we may say that the considered document passport.
Yes.
Yes.
But
then
everything considered.
Once it is considered,
Everything considered.
whether it is properly appreciated or not appreciated, that is not our business.
Not
Until and unless there is something perverse.
Even the order itself speaks of. You have instance that he said, his counsel said, I have no document at all. I have produced it.
See,
then it proceeded.
Anyway, hard learned counsel. What is as requested by Mr. Petitioner or other counsel for the petitioners? Finish this matter after a week.
Lordship.
We'll make sure we will finish it.
Lordship, Lordship.
Please. Otherwise, again, you have to remind the court again and again. And there are a number of akinkas going on. You see, like if there is a gap in between, matter becomes
one case I finished after 20 years.
Into 1, 2, 2, 3 matters, maybe something like that. It becomes difficult. Yes. Is there any other matter after this?
Deep level,